Hi, I'm Hillsborough County Commissioner Sandy Merman. I'd like to take this opportunity to remind you how important it is to take time to prepare and make a plan for hurricane season.
I'm Tim Dudley, your emergency manager. We've learned many valuable lessons over the years and want everyone to be as prepared as possible this storm season.
In these uncertain times, it's more important than ever to have a plan and be prepared. COVID-19 has shown us that coming together as a community and being resilient is key.
Our team is working hard to keep Hillsborough County ready for any disaster and to provide our residents with resources in case of a hurricane.
To make sure you're ready this year, the first thing you need to do is to sign up for HCFL Alert. You'll receive current emergency information by phone or email.
Next, make a plan with your loved ones. Knowing your evacuation zone and evacuation route is crucial. If you have to evacuate, consider reaching out to friends and families that live outside the evacuation zone to see if they can host you.
If staying with friends or family isn't an option, you can always consider hotels or motels outside of the evacuation zones.
That's right. Hillsborough County emergency shelters are lifeboats, not cruise ships. They should be considered a last resort to keep your family safe.
If Hillsborough County emergency shelters are your only option to evacuate, come prepared. You'll need some additional items this year, including face masks, gloves, hand sanitizers, and other personal items.
At Hillsborough County emergency shelters, you should be prepared to practice social distancing and come with your emergency kit and the items your family needs. Remember, shelters are not a resort. Their last resort. They won't offer any amenities and resources may be limited.
During storm season, you should also keep your gas tank full and keep your emergency kit close at hand.
Make sure to check supplies in that kit, including medication, radio, flashlights, and batteries.
And as we mentioned, due to the COVID-19 pandemic, please include face masks or coverings, hand sanitizers, and gloves.
I want to echo what Commissioner Merman just said. These additions are essential for your health and that of others, especially if you need to go to a county shelter.
In addition, do not forget to pre-register loved ones who require special needs accommodations. Hillsborough has programs in place to help those individuals prepare and find safe shelter.
And don't forget about our furry friends. You'll need food, a pet carrier, proof of current vaccination, and your animal's county registration tag.
Have a plan, know your plan. For more information, please visit hcflgov.net/stay safe. Thank you.
Hillsborough County, along with local and federal health experts, are encouraging residents to wear cloth face masks to cover their nose and mouth when in public to help stop the spread of COVID-19. There are not enough surgical face masks for everyone, and available ones should go to healthcare workers and first responders. It's easy to make your own face mask out of common household items. The CDC and U.S. Surgeon General say you can use an old scarf, bandana, or make one using a t-shirt plus 2 rubber bands. Cut part of the t-shirt into a square, fold it from the bottom to the middle, then from the middle to the top. Repeat those steps one more time, then add a rubber band to each side. Bring each end to the middle, then secure around your face. They should fit snugly but comfortably. Cloth face coverings should not be placed on children younger than 2 years of age or people who have trouble breathing. The CDC emphasizes that while wearing a face mask, you should still practice social distancing, stay 6 feet apart from others, and continue other preventative measures such as frequent hand washing. We encourage you to visit hcflgov.net/stay safe for up-to-date information.
Is your local business or organization looking to give back to the community? Help keep our roads clean by joining the Adopt a Road program administered by Keep Tampa Bay Beautiful. Keeping our roads clean is a great way for team building as well as exposure for your business. Select the road your business wants to adopt and dispatch a team to remove litter and debris. Participants will receive 2 signs showing their organization's name as well as safety equipment and instructions for cleaning roads. You can help keep Tampa Bay beautiful by adopting your own road today. To learn more, visit hcflgov.net/cleanhc.
Hello, I'm WWE superstar Titus O'Neil, and today I'm coming to you as a neighbor. You owe it to yourself and those you love to get tested now. Get the care you need and protect your family. Hillsborough County is offering free coronavirus testing and no health insurance is needed. It costs you nothing to get tested. Visit hcflgov.net/stay safe for more information and have a reservation made today. Share this with a neighbor, and let's come together as a community and keep fighting to get through this. Together, we will come back stronger. God bless.
So let's say that Tim here was returning to his vehicle only to find it missing. He may think it was either stolen or towed. Let's not worry too much, Tim. Hillsborough County wants you to know the rules and regulations should you find yourself stuck in this unfortunate situation. Here are a few rules and tips you should know. Rule number 1, permission to tow. Towing services need permission to tow from private property and must post signs with telephone numbers saying that the trespassing vehicles will be removed. If your vehicle is missing, look for a sign and call the number. Rule number 2, communication. As soon as your vehicle is delivered to the local towing facility, towing services must notify local law enforcement within a 30-minute time frame, and they must return calls from vehicle owners within 1 hour. Helpful tip number 1. Law enforcement can help motorists determine if their vehicle has been towed. If you don't see a posted sign, call the authorities on the non-emergency line. Rule number 3, retrieving your vehicle during a tow. Most people are unaware that you can still retrieve your vehicle while connected to the tow truck. For a drop fee of no more than half the towing rate, the tow truck operator must release the vehicle to its owner. When it comes to payment, tow truck drivers must accept the following: debit, cash, cashier's check, or money order. Rule number 4, personal property. If the owner is unable to pay the drop fee and their vehicle is in the hands of the towing company, owners still have the right to retrieve personal property from their vehicle. Helpful tip number 2. Having a registration and title in your name will make it easier to recover your vehicle. Tow companies will not hand over the vehicle if you are not the registered owner, unless you have an original notarized affidavit signed by the registered vehicle owner. Remember, Hillsborough County is here to help you. For complete detailed information on towing rules and regulations, please visit us at hcflgov.net/consumer protection or give us a call at 813-635-8316.
Hillsborough County has opened a majority of its conservation parks, trails, and nature preserves to give residents additional options for recreation and exercise. While parks can provide an escape and excitement, county leaders are urging residents to take precautions to protect themselves. To help stop the spread of COVID-19 while in public places, use common sense. Stay home and avoid parks if you're feeling sick. Practice social distancing. Avoid groups or gatherings larger than 10 and stay at least 6 feet from others while exercising. In addition to social distancing, Hillsborough County leaders continue to urge residents to wear cloth face coverings when in community settings. Bring your own water. Though parks are opening, many amenities will remain closed. Prepare for your visit by packing necessary items like hand sanitizer, and it's a good idea to bring your own disinfectant wipes to wipe down any public surfaces before touching or when touching public equipment. But remember, don't flush them after using. Residents who do not abide by the social distancing requirements or listen to instructions from county staff while enjoying the parks will be asked to leave the property. We encourage you to visit hcflgov.net/stay safe for up-to-date information. Hillsborough County has teamed up with the Department of Health and other public health and safety agencies to address any impacts the virus may have on our local community. To help prevent the spread of the coronavirus, here are a few tips you should know.
I pledge allegiance to the flag of the United States of America, to the republic of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Well, good morning, everybody, and welcome to the August 18th, 2020 meeting of the Hillsborough County Land Use Hearing Officer. My name is James Scarola, and I'll be the hearing officer for this morning. What we'll do to kick off our hearing today is first you'll hear me discuss with staff any changes to our agenda. So you might want to pay attention to that, and just in case any petition you're interested in is involved. And after that, I'll go through a short set of procedures with you on how we'll conduct the hearing, and we'll move right on into it. So with that, I'd like to introduce you to Mr. Tom Hisney of the Development Services Department. Good morning, Tom.
Good morning, Mr. Scarola. To my left, I have Carmen Mason. He's with Development Service Hearing Operations staff. Our meeting is also being joined by Cameron Clark of the County Attorney's Office. He is joining us virtually. We have a few changes to the agenda. One is dealing with item I-1, Appeal 20-1035. The applicant in this case is Sumter Davis, not Kathleen Weber as shown on the agenda. Also, I'm going to be reading off some withdrawals and continuances. There's been a change in the date that several of these are being continued to. Many of them were being continued to September 29th, and that's going to be changed to September 14th, and I'll read those into the record as I go through those.
Thank you.
Yes, sir. Okay, with regards to withdrawals and continuances, item A1, special use 19-1174, applicant Denise Donaldson. This application is being continued by staff to the September 14th, 2020 Land Use Hearing Officer meeting. Item A2, variance application 20-0244. The applicant is Russell Capel. This application is out of order to be heard and is being continued to the September 14th, 2020 Land Use Hearing Officer meeting. Applicant, item A3, variance application 20-0317. The applicant is John Schuman. This application is out of order to be heard and is being continued to the September 14th, 2020 Land Use Hearing Officer meeting. Item A4, variance application 20-0372. Applicant is Martinez Yane and Mujika. Martinez Yane and Mujika Maria. This application is out of order to be heard and is being continued to the September 14th, 2020 Land Use Hearing Officer meeting. Item A5, variance application 20-0398. The applicant is Eloy Martinez. This application is out of order to be heard and is being continued to the September 14th, 2020 Land Use Hearing Officer meeting. Application A6, item A6 rather, variance 20-0601. The applicant is Ivan Perez. This application is out of order to be heard and is being continued to the September 14th, 2020 Land Use Hearing Officer meeting. And finally, item A7, variance application 20-0803. The applicant is Heather Ryan and Robert Heath. This application is out of order to be heard and is being continued to the September 15th, 2020 Land Use Hearing Officer meeting. That's all the changes, continuance and withdrawals.
Okay, thank you for that, Tom. So ladies and gentlemen, if you're interested in looking, that's on page 4 of your agenda at the top, and with Mr. Hisnay's changes noted. So with respect to our hearing, the hearing is generally going to be informal. Questioning will be confined as closely as possible to the scope of direct testimony. And what that means simply is that when you come up to this podium, you'll just be speaking with me directly. As the hearing officer, I'll call and question witnesses as necessary and appropriate, and I'll be deciding all questions on procedure. Irrelevant, immaterial, or unduly repetitious evidence is going to be excluded. Any part of your evidence may be received in written form. All of your testimony today is going to be under oath. Hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but it won't be sufficient in itself to support a finding unless it would be admissible over objections in a civil action. So having said that, the basic order of the presentation is going to be as follows. First, Mr. Hisnay will briefly introduce each petition, and the Development Services staff will come forward and give a summary of their staff report. At that point, the applicant and any of their witnesses can come forward and present their testimony and evidence on the application, and they'll have a period of up to 15 minutes to present that. I'm going to then turn to anybody in the audience that is in support, so any proponents, but that's not the applicant. Again, those are other parties that might be here in support, and we'll set aside a total of up to 15 minutes for any of that testimony as well. At that point, I'll turn and ask if there's any opposition in the audience. For those in opposition, we'll set aside a total time segment of 15 minutes for opposition. If there's more than one speaker, I'm going to simply ask how many we have, and if you haven't assigned a primary speaker, then we're going to just divide up the time the best we can into the 15 minutes. At that point, I'll turn to staff and see if there's any changes to the request. And I'm sorry, to the staff reports. And then lastly, the applicant will have the opportunity for a final rebuttal. By the way, these procedures I'm outlining are for the variances we're going to hear today. There's some slightly different procedures for one appeal that's going to come forward towards the end of our hearing, and we'll go over that at the time. So, a couple of tips for you when you come forward. When you come up to this podium, there's a microphone up there. Always pull it down close to you when you go to speak. I know it's difficult wearing a mask, as I'm illustrating, but your name and address first. Name and address when you come forward. If for whatever reasons you had to sit back down and come back up again, always say your name first before you go to speak. That's because there's a record being recorded, and we need to know who's speaking into the record. You don't need to repeat your address, but always when you come forward the first time, name and address. Speak clearly into the microphone, and when you're all done, to my right, the clerk has a sign-in sheet. So you'll go from the podium to the sign-in sheet and sign in, and that will complete the fact that you testified and presented evidence. So at this point, we have an assistant county attorney representing today Hillsborough County, and will provide you information with respect to your rights to appeal decisions resulting from after today's hearing. So with that, I'll turn it over to Mr. Cameron Clark of the County Attorney's Office.
Thank you, Mr. Scrolla. Good morning. My name is Cameron Clark. I'm an assistant county attorney. Be advised that the language I'm about to read to you applies to the following case numbers: E1 on the agenda, and also items G1 through G5. What I'm about to read does not apply to the appeals case, which is Appeal 20-1035, Appellant Sumter Davis, as that is already an appeal, and so there's no appeals process for it. So for the applications I just stated, E1 and then G1 through G5, the following is the appeals process for those cases. This land use hearing officer public hearing is for variance requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the appeals board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the appeals board. In reaching a final decision on petitions, the appeals board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the appeals board hearing shall consist of oral argument by the party appealing the decision, by county staff, and by any interveners, each of whom may be represented by legal counsel. The following shall stand to appeal a decision of the hearing officer or to intervene in the appeal. First is the applicant. Second is anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the appeals board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the appeals board disregard evidence or testimony outside the record made at today's hearing. Any evidence presented to the appeals board that is outside today's record could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action then is for you to write down any comments that you make today and to repeat those comments to the appeals board. Thank you.
Okay, thank you for that, Mr. Clark. All right, now if you plan to come forward today to provide any testimony or evidence with me, whether you're appearing virtually or in the room, please rise now and raise your right hand, please. If you're going to speak, rise now. Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Okay, I think with that, we're ready for our first petition. Mr. Hisnet.
Right, our first, we have no vested rights cases today, no fee waivers, no reconsideration requests. So that takes us to section E of our agenda. First case is item E1, variance application 20-0640. The applicant is Osneil Escudero. The request is a variance to encroach into wetland conservation area setback. Staff findings will be presented by Carla Shelton.
Okay, good morning.
Good morning. Good morning. This is Carla Shelton with the Development Services Department. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on March 2nd, 2020, is to allow for after-the-fact placement of concrete pavement, a shed, and a gazebo within the 30-foot wetland conservation area setback. Per LDC section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests after-the-fact construction of concrete pavement, shed, and gazebo within the 30-foot wetland conservation area setback. The applicant requests a 25.5-foot reduction of the setback to allow for a setback of 4.5 feet. Staff findings: this property has been cited for unpermitted land alteration activity, citation CE 185290, and has an order from the Hillsborough County Code Enforcement Special Magistrate to obtain a variance to allow the wetland setback encroachments and to obtain a natural resources permit to address the impacted wetland setback, among other items. That's all from staff.
Okay, come forward. You should probably distance, so prefer whoever's going to speak first. You need to get on the microphone. You need to get on the microphone, no matter what you say.
Okay. Yeah, he's not that good in English, so we will need something in Spanish. So.
If you're asking me, you do speak English or no?
Yeah, I speak English.
Okay.
But not him. So I'm here representing him for the,
Name and address.
his name?
No, your name.
Mine is Omar Milian, Omar, and the address is 7021 Monterey Lane, Tampa, Florida, 33625.
Thank you, sir.
So we are here representing him because he's applying for this variance for the wetland setback, and because of the storm that he suffered on the years ago, so he had to clean the area. And without knowing, he just prepared the backyard because to protect his family, because at that date, his wife, she had a daycare at home. So she thought, or he thought, that it was better to protect all that area from the animals, you know, from to come for the kids and everything, damage the kid. And that's what he did. That's what we're applying for.
Well, the permit is for excavating or placement of permanent structures. Let's see, what you describe to me what's in the setback.
In the setback is just a, you know, the area that he changed is just concrete, and then we got like a little shed and a little gazebo. That's it, nothing else.
Okay, and was there a permit pulled?
No.
And what was the reason that a permit wasn't pulled?
Because he didn't know about it. He did a long time ago, but he didn't know about it.
How long ago?
¿Cuántos años hiciste el concreto? About 3 years ago, or something like that.
About 3 years ago. When did he acquire the property?
2010.
2010. Okay. Now, so in order to obtain a variance, you have to satisfy the criteria, of which you've provided some responses, but especially the one with respect to explain how the situation sought to be relieved by the variance does not result from an illegal act or from the actions of the applicant, resulting in a self-imposed hardship. Can you describe to me how this does not result from his own actions causing the self-imposed hardship?
Well, the thing is that he just cleaned what the storm did. And
Wait, say that again. Get that microphone closer to you. I can't hear every word.
I'm sorry.
Yep.
Okay. He just cleaned what the storm did to the wetland, and like that, it's his own property. He didn't went inside all the other properties. It's just.
Let me make sure I understand. You're saying he just cleaned.
Yep.
But he cleaned with a concrete pad and driveway and a gazebo and a shed.
No. At the beginning, he just cleaned what the storm did, and then without knowing, he did the rest: the concrete, the little shed, and the little gazebo.
Without knowing what?
Without knowing that he cannot do it.
Mm-hmm. Okay.
That was the main point. Nobody advised him at that time that he cannot do that.
Right, but it was still his actions that caused it, regardless of whether he didn't know. He
Understood.
Right?
Yeah. That's why we're applying for the variance.
Okay.
We got a plan also. We went to the county office and we got a plan of replanting all that area. We already submit the paperwork with the plans and everything. They approve it, and he's willing to do it and do whatever needs to be done to solve the problem.
Okay. Along those lines, let me ask staff a question. Just give me one moment. Carla, are you still listening?
I am, yes.
Carla, you've reviewed the planting plan?
We did review the planting plan. The planting plan does provide an equivalent amount of compensation to the amount of concrete that was placed, but that's what the compensation planting guidelines require. So that's all I can say is approved, is that the planting compensation is equivalent to the amount of concrete that was placed.
Was there enough left behind for you to discern whether there was any impact to to the wetland in a way, not to the wetland itself, but in a way that would cause secondary impacts to the wetland for impacting the wetland conservation buffer?
I believe there actually were impacts to the wetland itself. There is no vegetation left currently in that area. I wasn't directly involved with the violation portion of this, but I do know there was significant impact.
Carla, the voice quality was really bad. Can you try moving the microphone a little closer to your mouth and give me the last couple of lines again?
Sure. I was not directly involved with the violation itself, but I do know that there was pretty much no vegetation left after the impact occurred.
Okay, thank you, Carla. All right, sir, you're welcome to respond to anything that Ms. Shelton just said, and you're also, if you need to have more testimony, you're welcome to put it on the record.
Yeah, I can barely hear it. But also, Jill, let me tell you that we only have the plan, we just cut a lot of concrete just to give less impact to the wetland and to have more planting area. So we're ready to do it.
So when was that done?
It was like, it was about 7 months. He cut the concrete and put a little more of dirt and level it like that. But we are not inside the wetland as well. We are just on the border.
Understood.
And we think that if we plan that with the dirt we install, the level and everything, it's going to look like the wetland, you know? It's going to be pretty good.
Okay. Anything else, sir?
No.
All right, thank you for your testimony.
Thank you.
Is there anybody here today in support of this? Sir, yeah. Step over here and sign the roster. Anybody here today in support of this request? Virtually or otherwise? I see none. Is there any opposition to the request? Yes, sir. I'm sorry, we have 2 people? Anybody else, so I know what I'm in for here. All right, so we're going to put 7 minutes on the clock for you. Come on, sir. Okay, 3 at the most, so you have the rest of that.
May I give you one of these?
You know, the best way to do it is to hand that to the clerk.
Okay.
And then you can display yours. Yeah. I can hear you. He's going to be
Thank you.
12. Yeah. Okay, I can see that.
Thank you, sir.
Good morning.
Good morning. I am Dennis Radke, 5945 Birchwood Drive, Tampa, Florida, 33625. We are here today because the homeowner at 5923 Bitterwood Court was found in violation in February 2020 and was ordered to remove everything he constructed and restore the area back to its natural state. He then filed for this variance. I, Dennis Radke, and my wife own property 5945 Birchwood Drive, which is a wetland conservation lot in the Cedar Creek at Country Run Development, the same development of 5923 Bitterwood Court.
Which direction from his house are you?
Straight south.
Due south? So you're across the cul-de-sac?
We're a street over. We're like a street and a half over.
Street and a half over, okay.
Yeah, about an eighth of a mile. Our property was purchased in 2001, and the selling point was that it abutted the wetland conservation area, an area that is dedicated to conservation, preservation for foliage, wildlife, and the like. In 2008, I became more involved with the community HOA as a member on the architectural committee. 2009, 2011, I was the HOA treasurer, and in 2012, I became the president, which still is my position today, along with being on the architectural committee.
And I'm sorry, just a point of clarification, is the subject lot in the association?
Yes.
Okay.
And yes, I am very passionate about our community. HOA history, a little background. Before I became involved with the HOA, the previous HOA board had to contend with a company wanting to build a retirement-style, multi-story building off of Henderson Boulevard, which borders our conservation lands, in which if they were allowed to build, it would encroach into the Cedar Creek Wetland Conservation Area. At that time, I did attend the meetings that involved the HOA and the company wanting to do the building, which consequently was canceled. This was a win for our community. 5923 Bitterwood Court history. The HOA requested the county to investigate trees being cut down and trees being cut down, the use of large trucks, dump trucks, and loads of dirt being hauled into the property of 5923 Bitterwood. The owner indicated that the trees were knocked down by storms. I have lived here since 2006, and we have had no such storms. Please see my satellite timeline from the years of 2013, 18, and 20. No trees were ever knocked down from storms. All work completed at 5923 has been done without any permits. Once Hillsborough County was aware of this, the owner was advised to stop all work by the county, but the owner continued and completed the work. This owner, after being told by the county to stop, continued. At this point, the county alerted the Environmental Protection Commission, the EPC, because the actions of the homeowner encroached into the wetlands, which is the jurisdiction of the EPC, which you can see. As a homeowner who relies on government agencies to protect me and my home, I am disappointed that the EPC appeared, I'm sorry, I skipped a line. I'm going to back up. Thank you. The EPC visited the property. I was told by an employee of Hillsborough County that the EPC then moved the boundary of the wetlands farther into the woods, which then made the actions of the homeowner a county violation. As a homeowner who relies on government agencies to protect me and my home, I am disappointed that the EPC appears to have gone against their own seal by protecting the environment by moving the wetland boundary back. This concerns me because if one homeowner is allowed to have the boundary moved back, what's to stop others from being permitted to do the same thing?
Let me stop you right there. I do want to ask a question about that, but I also don't want to belabor the issue. In effect, you've come to the conclusion that they moved the line back. What pieces of evidence led you to believe that they actually moved the line as opposed to set a line?
The only thing I know is what the county person that I spoke to had mentioned to me that after the EPC made the visit, they moved the wetlands back. That's all I recall being told.
So you haven't compared the original plat, which typically, I don't know when it was platted, but typically most modern plats of any kind have the wetland line established. You haven't compared that against where they ended up with it.
I have not.
Okay, it's fair enough. I just wanted to make sure.
I did ask. I never received anything. The best I received was what's on my board there.
Okay.
This concerns me because if the homeowner is allowed to have the boundary moved back, what's to stop others from being permitted to doing the same? Then what happens to our wetlands? I'd like to ask which agency is responsible for making decisions regarding the construction at 5923, or could this fall under both the EPC and Hillsborough County agencies? In my satellite views, we show a missing tree line of two properties. Not only have the homeowners at 5923 removed trees, added fill dirt, concrete, and added a building, the homeowners at 5921 have done the same thing. This also should not be allowed. You can clearly see from the satellite views I provided what damage the property owners of 5921.
Okay, hold on.
Yes, sir.
I would like you to stay away from the other one because it's not the hearing for them and it's not fair. They're not, maybe not here. So if you would stick to what's at hand.
Okay. We are in real time watching an owner callously destroy what took generations to grow. You see the trees removed. You see the fill dirt added, and you see the additional buildings and concrete, which is in my 2019 satellite view. Next, I would like to address the owner's response to the variance criteria and the HOA's comments. The owner claims these actions were done to provide a safe place for his daughter and wife's daycare children to play. The HOA response: first, a daycare is not permitted in this community. Second, his actions negatively impacted the wetlands and drainage area. Two, the homeowner claims by doing what he did, he now controls issues with snakes, critters, and wildlife and the like. The HOA response: the wetlands are dedicated to be a safe sanctuary for wildlife and should not have been disturbed. Three.
But, hold on.
Yes, sir.
Did they disturb the wetlands?
Yes, well, they're in the setback.
But you said they disturbed the wetlands.
They removed trees from the wetlands.
So not that I know of. Do you have any evidence of that?
On my board,
Well, does your board show where the wetland line is? So you gotta get on the microphone. Yeah, you're welcome to hold that. The issue that we're skipping across here is that there's a wetland setback, and then there's the wetland. And your terminology has gone to impacting the wetland. And nothing, I can tell you, no evidence is in the record of an impact in the wetland. Like, that's where EPC's jurisdiction is. And by the way, it's not mine. It's not mine. The wetland setback area is where a variance is being requested. So when you say and I'm not going to quote you, but your words were impacted the wetland somehow. I don't see that, and I want you to know I don't see that.
Okay.
So keep going.
the homeowner claims they did not cause any difficulties to any neighbors. The HOA response: he filled in a dedicated wetland drainage area, and that does affect the neighbors. Number four.
Okay,
Yes,
let's
sir.
understand that wetland drainage area. We know it's a wetland conservation area. By the way, it could be a drainage area in addition to that if there's some sort of, the construction plans for the development originally, or an easement that indicates a drainage easement. Have you seen anything like that?
No, I have not. All I know is I was told that from the pond over was drainage area, that this area here is drainage.
Do you know if a copy of the plat got into the record at all?
No, I do not.
All right.
Homeowner states that if he has to remove what he installed, he then would not be able to enjoy his backyard, which is a right everyone has. The HOA response: he purchased the property knowing that the area was a dedicated wetland and it must remain undisturbed. Item 5, the homeowner says he has not taken any land from anyone else. The HOA response: he has. He took dedicated wetlands, which is to support the entire community. Homeowner states no illegal activity was done. The HOA response: no permits were pulled for any part of the work. The homeowner is part owner of OB Trucking Company. That being said, he should have been aware that permits and approvals are required for the type of construction he completed. The homeowner claims in-laws are living at the property, and if he has to remove the cement, the in-laws will have to move. HOA response: this community is designated for single-family homes, 2 to 3 bedroom homes. They are not meant as multifamily homes. Where exactly are the in-laws living? Are they in one of the outbuildings? Our conclusion: this project completed by these homeowners bears all the earmarks of a well-planned business venture between 3 individuals. There is no hardship here on the part of the owner. This is a self-serving act. It is a hardship on the wildlife and nature, though. Wetlands were lost. We cannot allow anyone to encroach on a dedicated wetlands area. I understand. Setback. Cut the trees down, fill in a drainage area, and cement over it. With the research our community has done, we have learned that the owners of 5921 and 5923 are owners of OB Trucking. We also are aware Omar is also part of this business venture. This raises the following concerns. To complete the work that these owners have done, heavy equipment such as dump trucks, bulldozers, leveling equipment, cement trucks, and manpower had to be used.
Sir, if you would just begin wrapping up. It sounds like you're getting there anyway, but I'll give you a little bit.
Thank you. One can only assume that these owners use their own equipment and manpower from their business, and we know that no permits were pulled. These owners both have installed fences with gates wide enough to allow heavy equipment access into the backyard, which they have proved they are doing for that purpose. This provides the opportunity to eventually start storing heavy equipment in their backyards on that huge cement slab. The concern here is that that equipment could start leaking petroleum fluids that will drain into the dedicated conservation area. When that happens, again, the surrounding owners will be negatively affected, as will the wildlife, foliage, and Florida aquifer. Out of our 195 homes, I have here owner emails against allowing the approval of this variance. Our request is that this variance be requested by the owner at 5923 Bitterwood should not be approved. We are requesting the removal of all added buildings, concrete, fill dirt. Additionally, we request that the owner be directed to plant replacement trees, shrubs, wild grasses, and return it back to its intended state of a dedicated wetland conservation area. Doing this will help the land get back to its natural state, which took generations to grow. Thank you.
Obviously, I've got a lot of review to do, but I did want to leave you with some fundamental differences in your testimony from what I see. I don't see any wetland impacts. Okay, that's an important element. And by the way, as I mentioned, out of my jurisdiction, that's purely EPC. If it's a wetland impact, wetland conservation area impact, that's what's in front of us today with respect to a variance for how much encroaching into it. And a planting plan is a component of what the application shows as well. Having said that, I understand, what's happened here.
Thank you.
I did want you to at least know that side of it. Okay. Thank you for your testimony. All right, the other gentleman for 3 minutes. Elise, can we put 3 minutes on the clock? Morning, sir.
Good morning. Thank you. My name is Kent Bailey, 15012 Highway 301. I am chair of the Tampa Bay Sierra Club. I'm here at the unanimous direction of our executive committee, speaking on behalf of 14,000 members and supporters. I'd like to point out that I submitted in the record via email this PDF copy of the plat, the original plat, which has an important note on it. I will get to in just a minute.
Okay. Let me just ask you about that while we're on the subject. I noticed it's an 8.5 by 11 piece of paper. Are you telling me that is a actual copy of the recorded plat?
Yes, that is pulled from, yes,
the public records?
Public records, yes, sir.
Okay.
And it is also submitted in my email.
Thank you, sir.
Yes. I would bring your attention to, this is from the March 2nd, 2020 survey that is also in the record, and point out that a portion of this wetland setback area is also a drainage easement line, which is noted on the March 2nd survey, and a copy of this also was submitted.
Well, that fills in a little piece of the puzzle, right? Thank you.
Yes.
For that.
Now, it has got nothing to do with what's happening today, but I would point out, nevertheless, that the drainage easement includes most of the area where most of the concrete has previously been placed, but that's a matter for another day.
Well, but I have to understand that a little bit. They mentioned concrete being cut away. I haven't reconciled the timing of what I'm looking at versus what was cut away. Do you believe they removed concrete, or they removed all the concrete from the drainage easement? Or do you believe there's still a conflict and overlap between the concrete and the drainage easement?
There remains concrete in an area that is common to the drainage easement and the wetland setback.
Okay, beautiful.
There remains a massive amount of concrete that is in the drainage easement that is, as far as I know, not been addressed by county regulation, by inspectors, or not been cited, no variance there. I'm not sure I've got that right. The area up here is the portion that is both drainage easement and wetland setback. There are at least...
Give me 1 second. I want to look at that drawing for just a moment. Can you, with your pen, trace out the drainage easement limits? Because you've been looking at it longer than I.
It's actually highlighted on this one. The drainage easement is here and over here. The area that is both is this area here. This is inside the wetlands, and also here's the drainage easement line coming across here. So this area here is both in the drainage easement and in the wetland setback.
Well, yeah, so I'm staring at that, what you tried to point out is the drainage easement line.
Yeah, that is noted on the March 2nd survey.
Yeah, I don't see a call off. I see the title, and because it's a portion of the, we'll leave that there, sir.
Yes.
Because it's a portion of the drawing, that's a line. Well, maybe I won't be able to figure that in here, but the plat shows the drainage easement, right? And
It certainly does.
And you're putting the plat in the record.
I've already done so, yes. Okay. There are at least 8 other parcels on this same street that share this condition in terms of boundary, including conservation area. This is not a unique condition for this property. This portion here of drainage easement, on the plat, there is a note which states very clearly that no paving, patios, driveways, decks, impervious surfaces, and other things are permitted in this area. There are no unique circumstances here. I also placed in the record the property appraiser's property tax report. The March 2nd survey calls out 2,414 square feet of wetland setback area that is currently valued at 2 cents per square foot. The upland portion of the parcel here is $9.34 per square foot, converting the 2,414 square feet of wetland setback to upland effectively nets the applicant $22,619.18.
Well, what's the short story here? Is it still shown on the property appraiser's map as wetland setback or wetland as opposed to improved upland?
That is correct.
Okay.
So, and the same goes for the drainage easement, which is the bulk of this, but not a part of today's proceedings.
Gotcha.
Any burden on the applicant is entirely self-imposed. And I close by pointing out that granting this variance constitutes forgiveness where permission would never have been given. It accrues to the applicant considerable financial gain and property value at public expense and incentivizes noncompliance by both the applicant and the general public. Wetlands are important public resource. Wetland setbacks are there to protect this important public resource in terms of the impact it has on wildlife habitat, aquifer recharge, water pollution, air pollution, floods, and more.
Secondary and cumulative impact.
Yes. So that concludes.
Thank you, sir. Appreciate the testimony. Okay.
Would you like these?
Just want to make sure nobody else in opposition. We cleared the online and nobody else? Okay, so nobody waiting. All right, with that, I'm going to close opposition testimony. I guess I want to make sure that Carla doesn't have anything else to add. Carla, are you still out there?
I am, and I do not have anything else to add.
Okay, thank you for that. And so, sir, you have an opportunity for a rebuttal of up to 5 minutes.
Here again. What I saw on his drawing over there.
Your name?
I'm sorry?
Your name?
Oh, Omar Milian. What I saw on his drawing over there, the line of the tree that he said he was cutting down.
What was what?
The line of the trees that he showed on his drawing.
Who is he? The last speaker or the one?
Yeah,
before?
on his the first one, yeah.
Okay.
On his drawing, the line is going far away when we add. After the inspection, he cut a lot of concrete, so that one, it was like covered back, and then we refill it with dirt and everything. That's the only thing that is different than what they say, you know? We didn't know about that drainage thing, but I don't think the concrete goes to there.
You don't think what?
The concrete goes to the drainage area. I think it stopped it before that because we cut it.
He just showed a survey.
Yep, we sent it to them, the survey and everything.
Was the survey pre or post cutting the concrete?
Oh, post, after cutting the concrete.
So the survey should be accurate for what's there today.
Well, I don't know about his survey. We sent to the county, it was everything there, but I didn't know about that drainage. But they can see it probably over there.
Oh, look.
What I see is that we are not that far into the setback of the wetland. We just, after cutting the concrete, we reduce all that area. And when we plant it and everything, I think everything will be solved. Well, we are ready to do whatever you decide to do to solve the problem. We're not going to be involved in this anymore.
Thank you, sir. Anything else?
Nope, that will be all.
All right, appreciate the testimony. And with that, we're going to close variance 20-0640. Stone?
Mr. Hearing Officer, this is Cameron. Can you hear me?
Sir, 1 moment.
Yes.
Go ahead, Cameron.
Mr. Scarola, can you hear me?
Go ahead.
The gentleman who just spoke, was he speaking on behalf of the applicant? I just wanted to clarify for the record.
Reopening. I'm reopening. Yes, sir. Come on up. Okay.
The reason
You
I was
stated
asking the
you were
question, if you could-
representative of the applicant. Can you clarify? Can you say I was speaking on behalf of the applicant? Is that the case?
Yes, I speak on behalf of them, yes.
And
Cameron, anything else on that?
Yeah, just could the applicant who was standing with him, if he could just place his name on the record, that would be good.
Come up to the microphone, name and address.
Oh, the number of the vehicle.
My name is Osniel Borrego.
The address?
My address is 5923 Bitterwood Court, Tampa, Florida, 33625.
Thank you, sir.
Thank you, sir.
Cameron,
Appreciate
anything
it.
else?
No, that's all, sir. Thank you.
Thank you, sir.
Thank you.
With that, we're going to close the variance 2640. Okay, Tom. Ready when you are.
Okay, we have no sign variances, so that takes us to section G of the agenda. Our general variances, first case is item G1, variance, application 20-0272. The applicant is Jason Kendall. The request is a variance to buffering and screening requirements. Staff findings will be presented by Laura Marley.
Good morning, Laura Marley, Development Services. The applicant is required to install a 10-foot buffer with type A screening to the north, south, and west property lines. The applicant is requesting not to install the screening requirement, which is a fence on the west property line, and from the north property line, the westernmost 472 feet. The applicant will install the buffer, the vegetation on that portion of the west and north property line where they're proposing not to install the fence.
Thank you very much for your testimony. And the applicant, please. Morning, sir.
Good morning. My name is Jason Kendall, 1316 Corner Oaks Drive, Brandon, Florida. I guess this project's for the Valrico Church of Christ. It was permitted in 2018 and constructed in 2019. As the church was ending construction, they started installing the fence as the type A buffer component along the north and west property lines. Several of the neighbors came out and asked if they could not install the fence. The church is just requesting to be a good neighbor and not install it. Most of the property is open, grass field, and the neighbors liked it. We actually have something signed by all of those neighbors requesting this. I submitted that originally, but I have that here with me as well, if you'd like to see it.
Once you're done, you can submit it to the clerk. It'd be great.
Okay. That's really it. They're just trying to be good neighbors.
Okay, appreciate the testimony. Thank you for that.
Thank you.
Anybody here today in support of this request? Yes, sir. Morning,
My
sir.
name is Paul Warren. I'm at 1614 South Miller Road. I'm at the far western end of the property. We definitely have a good relationship with the congregation there. I'm actually a member of the congregation. We have about a 1 acre lot that butts up to it. All the neighbors are very friendly, speaking over the fence. It's basically about a 5 acre grass field, so everyone's got a pretty pleasant view of everything. The areas that the neighbors would have been concerned about that back up to the back of the building, which is at the front of the lot, has a fence there, so there's no, unpleasant views for them. But for everybody else, probably 7 or 8 houses along the grass field, it's all open, very peaceful. Putting a fence up would hinder me, and that it would close me in the back. My views, being able to pull equipment in and out of my property, as I have a small roofing company. Also, I have a quarter mile long asphalt driveway that runs parallel from the main road back to my property, and that would also close me in there. If there's people pulling in the driveway, say Amazon's coming in, I'm leaving, it would cause a problem. So.
All right, thank you for your testimony, sir. Anybody else that needs to speak in support? All right, is there anybody here today in opposition to this request? Any opposition? Being none, anything else from the applicant? All right, with that, we'll close variance 20-0272. All right.
All right, next case is item G2, variance application 20-0345. The applicant is Austin and Hyacinth Hansel. The request is a variance to allow easement to be included in minimum lot area calculation and variance to lot development standard. Staff findings will be presented by Steve Beachy.
Steve.
Good morning, Steve Beachy, Development Services. I just hit the wrong button there. Okay, I'm going to share my screen so that I can show the graphic. Okay, can you see that?
Yes, we can. Go ahead.
Okay, very good. The applicant is seeking to create a 3-lot subdivision on a parcel zone AS1, which requires a 1 acre minimum lot size. They have 2 access easements on the parcel, access easement A and easement B. So if they need to get a variance, they're seeking a variance to allow the area for those easements to be included in the lot area calculation. If they did not include those easements, it would be less than 1 acre for each lot. So that's the first variance that they're requesting. The second, they're also requesting 6 other variances for each specific lot. And I'll move to the second slide here. For lot 1, they're seeking a variance for the rear setback from 50 to 25 feet. And also for lot 1, they're seeking a variance for the front yard setback, which is on McGrady Road, from 50 to 25 feet. For lot 2, they're seeking a variance for the rear yard setback from 50 to 25 feet. And for the side yard on the southern portion of lot 2, they're seeking a variance from 15 to 7.5 feet. On lot 3, they're seeking a variance from 50 feet to 25 feet on the rear yard setback. And on the side yard, the north side, they're seeking a setback reduction from 15 feet to 7.5 feet. I would also say the other thing is that there's a wetland drainage ditch in the bottom here, so the easement or the wetland setback exceeds the easement here, so they're not seeking any kind of variance for that area. And they also, if they want to pave that area, they would need to get a variance in the future to encroach in the wetland setback. That concludes my comments.
Mr. Beachy, one quick question for you. I noticed in the backup that, I guess in the applicant's original narrative, they made mention of the issue of minimum upland quantity per lot. I'm going to guess that was resolved somewhere in the review because I don't see that as a variance request. And can you tell me what you know?
Yes, that was resolved. There's on the survey, I'm looking for on the survey, the area where it talks about uplands. And I don't see that right now. We do not, no, that
it shows that on each lot description, it says total upland is one of the line items. I'm trying to find.
Yes, yeah, right below. Yeah, it's over 0.8 acres for each one. So that issue fell out.
Mr. Beachy. Okay, and the applicant, please. Good morning.
Good morning. My name is Michael Hutchinson, Hutchinson Surveying and Mapping, 2313 Ray Road. I'm the applicant's representative. She's not here today, so I'm here to answer any questions. I don't really have anything else more to say than what Mr. Beachy said.
Okay, do you have some sort of, were you authorized representative?
Yes, I am on
the application?
Yes.
Okay,
yes.
Great.
I'm just here to answer any questions or to give any insight. I'm the surveyor that prepared the plat.
Okay.
Any information you need on that, I can answer.
All right. I don't have anything else, sir.
Okay. One thing I do want to say about is the wetlands are basically just a ditch, and now they've, that drains the water from the back to the front to the big drainage canal, but they've taken 30 feet. So, I mean, I think that these people should get this variance because of this. The property that's been taken from them because of the wetlands is overburdening on them.
Well, it's a wetland and it has a setback, right? Is that what you're referring to?
It's not really a wetland, it's a ditch. And then they take the ditch, which they've overtaken, and then they take 30-foot setback from there. It's just a ditch, it's not a wetland. So I don't understand what the problem is with that there.
Well, let's probe it a little deeper. Did EPC claim it as a wetland?
Yes, they did.
So it's a wetland?
Yes, that's what they claim it as, but I'm just giving you my opinion as a surveyor. It is just a ditch that drains water. It's not a wetland. There's no vegetation there. There's just a rotted out ditch that's irregular. So I mean that's just part of it is that the area that they're taking is because of a ditch.
Okay, thank you for your testimony.
Okay, thank you.
Anybody here today in support of this request? Anybody in support? Seeing none, is there any opposition to the request? Nope. All right. With that, I'm going to go ahead and close variance 2345.
All right, next case is item G3, variance application 20-0569. The applicant is Jimmy Valdiviso and Ram Goel. They're requesting a variance to buffering and screening requirements. I will present the staff finding. The applicant is requesting a variance to the buffering or screening requirements for a proposed development on property zone CN. The land development code requires a 20-foot wide buffer with type B screening along the west property line of the subject site. Type B screening is required to consist of a 6-foot high solid fence or wall or a 6-foot high evergreen plant, together with a row of evergreen trees that are not less than 10 feet in height and a minimum caliber of 20 inches at time of planting and spaced no more than 20 feet apart. The applicant requests the following. variances. One, a 20-foot reduction to the required buffer width to allow 0 buffer width. And secondly, a reduction in the required screening to allow a 6-foot high masonry wall only without the row of trees.
Okay, thank you, Tom. And the applicant. Good morning, sir.
Good morning. My name is Jimmy Valdivieso. I work with Dr. Ramagul. I'm representing the person that is in charge for this the property in question.
Were you an appointed representative on the application?
Yeah, I'm Jimmy Valdivieso. I'm Jimmy Valdivieso working with Dr. Ramagul.
Okay.
Dr. Ramagul is the person authorized though, but I'm working with him. Yeah, we're basically just.
Well, hold on. I'm not sure I do understand that. Cameron, you still there listening?
Mr. Clark, can you hear us?
I hear you, sir. Do you hear me?
Yes, go ahead.
Before you go to speak, we're looking at the application right now. It's another representative question. So give us just a minute.
The application lists 2 applicants, Mr. Valdivieso.
Okay.
So it's one of the listed applicants on the application.
That's fine. Mr. Clark, thanks anyway. I think we got it.
Thank you.
Yes, sir.
Once again, my name is Jimmy Valdivieso. My address is 18406 Oriole Street, Lutz, Florida, 33558. I'm working with Dr. Ramagul, representing the person that is the owner of this property. Basically, we want to, back in 2008, this property was approved without any setbacks requirements. Now that we're opening the case in 2018, Southwest Florida Water Management District, they required a 100-year floodplain and also a detention pond, which it requires so much space. It's too big that actually we cannot compensate with this 20-foot buffer that is required per the county because we have a floodplain out there. So that's why we're requesting we're putting a lining screening on a 6 feet high wall on the west side, old west side, which is basically where all this floodplain is located at. That is required by the Southwest Florida Management District.
Okay. The site plan I have isn't very detailed, but there's a system of line work behind the building to the west side of the building.
Mm-hmm.
What do you think that's trying to represent?
I'm sorry, what is it?
So your site plan has a bunch of lines behind the building. You looking at it?
Oh, that's the floodplain. That's the detention pond, the proposed detention pond.
All right, let's keep talking through this because again, it's obvious I didn't get a labeled site plan. It looks to me like there is a detention pond for sure in the very southeast corner.
Yes, that is a detention. That is another detention pond that is required by the Southwest Florida Management.
And it looks to me, if I were guessing, that is not a detention pond in the west side, but maybe some floodplain mitigation.
Exactly.
Is that what it is?
It is. I'm sorry.
Okay.
It's a floodplain mitigation.
All right. So that is undeveloped land. It's just going to be, it's not going to be paved over. It's floodplain mitigation.
Mm-hmm.
So I'm sort of missing the point of why we're asking for a buffer variance, at least for that area, which is, 60% of the site in the north set. In the
yes, that's one of the main things. Also, I don't really. It's already we have a buffer up there, so I don't know why they're requesting a 20-foot buffer. Other than that,
well, it's not they, it's you, right? You're requesting the buffer.
No, I'm not requesting the buffer. They are saying that we need the buffer, a 20-foot buffer. This detention pond, this mitigation plan, it's needed because of Southwest Florida Management District.
Okay, let's define this discussion a little bit. First, the buffer has always been a requirement of the Land Development Code back as far as I can remember. A buffer is required, okay? You're requesting a reduction of the buffer, okay? But you're not showing any impact to the buffer on the west side of that building.
I understand, and I don't know why I don't know why I'm here, basically, because we already have this buffer.
Well, we're gonna get to that because I know of at least one reason why you're here, so hold on for 1 second. Tom, question for you. It looks to me like, and again, it's not labeled, so there's a little bit of assumption on my part, but it looks to me like this is remaining on the west side of the building. Let's go directly behind the building. That area is not going to be paved. It serves the same purpose and would make a legal code buffer distance.
Yeah, retention areas are permitted in buffer yards.
Right. So then we get to a little further to the south side of the building and along the west. It's clear that the driveway and the parking spots are going in there.
Yes, I mean, it's not scaled, but their request was for 0 buffer. So depending on that dimension there at the closest point, which perhaps the applicant could identify, yes, parking areas are not permitted in a buffer. Yes, sir.
Okay. So in short, here's what I'm taking from this. You didn't really need the buffer variance up to a certain point. And so along the west side of that building, it appears that you have the 30-foot buffer, at least for a certain distance. But because there's no details on the plan and I don't have a scaled version, there's nothing I can really tell. Do you know where the 30-foot buffer runs out along there?
Probably they're talking about the south part of the parking lot, because other than that, I don't know where exactly they were talking about the buffer. But
well, so do you know? Let's go to the southwest corner of the building. Can you picture that, where that is?
Yes.
Southwest corner?
Yes.
Is the distance at the southwest corner of the building to the west property line 30 feet or greater?
From the southwest to the property line.
Yes.
No, it's not 30 feet away. No. But you're talking about from the parking lot? Where's that corner in the parking lot?
Now let's go through this again. The southwest corner of the building.
Oh.
Don't say yes unless you know where you are.
I'm sorry. Yes. Southwest corner of the building.
Okay.
To the property line. Yeah.
To the west property line. The west property line.
It's more than 30 feet.
Okay. So if that's true, then everything to the north of that along the back of the building has the buffer. Okay.
Yeah.
So now we got to talk about south of the building. And clearly the parking spaces go into that area. Clearly the parking spaces do. Where do you stand with a parking count?
We're good on the parking count. We're already being approved on the parking count.
Say again.
We're already being approved on the parking count, the number of parkings that we need.
Well, but are you in excess of the code required parking?
Yes, we're already, like I said, we're already approved for that.
That's not, the question is, are you in excess? You have more parking spaces than the code requires.
Yes, we are. We are more. I don't know exactly what is the number, but I know that we are more.
Okay. So what hasn't been done here is the calculation of where that 30 feet runs out and where you need the buffer from that point to the very southwest corner of the site, because you do need some buffer variance.
Okay.
Do you have a site plan that's gone through development review?
Yes, it's been in development review. I'm not sure what is the final work from them yet, but this was the main thing, basically the variance. That's what they were like. First, the requirements, the observations was about the variance that we needed to move forward on this. So that's why I kind of went and stopped by. But on site development, it's already they already approved, and we already have comments. This job is being on since 2018. So we're already.
I got all that. I'm looking for some detail here, in which I don't have. Have you got a copy of that site plan that was submitted, especially the grading plan, maybe?
No, I don't have a grading plan with me.
What do you have?
I just have only just probably what you have, but in better.
Well, that's got a lot more information I can tell you from here, because this is what I have, and it's got nothing. All right, is that, in fact, the plan you're trying to get approved?
Yes.
Okay, do you care to submit that into the record?
No, I don't mind. No.
You will?
Yeah, I can submit this for the record.
Okay. All right, any other questions, sir? Any other information? Anything else you need to put on the record? Well, so go back to the microphone. No, the microphone.
Okay.
Tell me if there's anything else you need to.
No.
All right. And when you're done, go sign in over here and hand the clerk the site plan that you're submitting into the record. She'll take it from you.
Okay.
Okay?
Thank you.
All right. Is there anybody here today in support of this request? Any proponents? Seeing none, is there any opposition to the request? Any opposition? One more time. Okay. Tom, anything else to add to that?
No, sir.
With that, we're going to close variance 2569.
Okay, our next case is item G4, variance application 20-0593. The applicant is Tammy and Richard Connolly. The request is variance lot development standards and a variance to accessory structure requirements. Staff findings will be presented by myself. The applicant is requesting several variances to accommodate existing building conditions on a single-family lot zoned RSC6. So there's an attached carport in the front of the house. The code requires a minimum setback of 25 feet and a minimum front setback of 25 feet and a minimum side yard setback of 7.5 feet. The applicant is requesting the following variances for the carport. 1, a 25-foot reduction to the required front yard setback to allow a front setback of 0 feet, and 2, a 3.3-foot reduction to the required side yard setback to allow a setback of 4.2 feet from the east property line. The variance is also being requested for the existing single-family dwelling. A minimum side yard setback of 7.5 feet is required. The applicant requests a 3.5-foot reduction to the required setback to allow a side setback of 4.0 feet from the east property line for the front corner of the existing home. There's a detached shed on the, on the west property line. Code requires that accessory structures less than 15 feet in height may require occupied side yards, provided they are more distance from the street than any part of the principal structure on the same lot and any lot abutting said required side yard, and provided the accessory structure is set back a minimum of 3 feet from the side property line. In this district, a minimum side yard setback of 7.5 feet is required. The existing shed is not located more distant from the street than any part of the principal structure on the same lot and the west neighboring lot. Therefore, a minimum side setback of 7.5 feet is required. The applicant requests a 7.5-foot reduction to the required setback to allow a side setback of 0 feet from the west property line for the shed. And then finally, there's a detached jacuzzi in the rear yard. Again, accessory structures less than 15 feet high may occupy required side yards where they are more distant from the street than any part of the principal structure on the same lot and any lot abutting said required yard, and provided the accessory structure is set back a minimum 3 feet from the side property line. The applicant requests a 2-foot reduction to the required setback to allow a side setback of 1 foot from the west property line for the jacuzzi. One finding here is for the natural resources staff, a permit for a seawall along the rear of the property was issued by the Tampa Bay Port Authority. Therefore, no conservation preservation area setback is required in the rear yard.
Thank you, Tom. And the applicant, please.
Good morning.
Good morning. I'm Tammy Connolly, 8502 Magnolia Street. All of these structures were in place when I bought the home a
What year
little
was
over
that?
4 years ago. I'm sorry.
What year was that?
I believe 2015.
Okay.
None of the accessories are seeming to bother anyone. They're not in the road. They're not on anyone else's property. Not really sure what questions you might have for me.
Well, so do you have a copy of your site plan with you, your survey?
I do.
Lay it down next to you on that overhead. Thank you. Could you take your pen and point to both the jacuzzi and the shed?
Okay.
Where's the shed?
Right here. Right here.
Oh, is it long?
Yes, it is.
Okay,
It's very long with several doors.
got it. And it's right up against the property line?
It is.
Okay, and then the jacuzzi?
The jacuzzi's here.
All right. And another question for you. The remainder of lot 14 to your east, do you own that?
I do not.
You do not own it?
I do not.
Did you own it at one time?
I did previously, yes.
And when was that sold?
Just a couple months ago.
Did you sell it to a
I sold it to the owner of the rest of lot 14.
so that would be the neighbor further to the east?
East, correct.
Okay. Give me 1 second. In doing so, did you cause a reduction in the setback on your east property line?
Did I cause a reduction?
Yeah, and let me explain. You own the property, so it was all one parcel,
Right.
and you had plenty of room to your east.
It was on the east, it's a matter of about 5 feet, and it's only in the rear of the property. It really doesn't extend much towards the front, that extra boundary.
I'm not sure what you're referring to. One of the variances is a minimum side yard setback for the single family home, 7.5 feet. And you want to allow a side setback of 4 feet, which I take it is it's labeled on your plan, actually, right at the southeast corner of the house. It's 4 feet.
Mm-hmm.
Do you know where that is?
Southeast corner, yes.
It says 4 feet. Somebody hand wrote it there?
Yes.
Okay. So you're asking for variance to go to 4 feet of setback, but you previously owned the property to the east, right?
I didn't own all of it, no. I owned just a sliver of that property.
How wide was the sliver?
It was approximately 5 feet only in the rear area, about halfway down the house. It's where the large mark is. It's the difference between that large line and the small line. It's very minimal. I'm not sure why it was ever included, but it was when I purchased the property.
Well, I think you're explaining something good. So as you look at that vacant piece of land there, you didn't own that whole thing. You owned
No.
a 5-foot strip.
Correct.
That is trying to be shown with that black line on the drawing?
Correct.
Okay. Anything else, ma'am?
We're just requesting to leave everything the way it is. It would cause us a great financial hardship to move these things. And, it really wasn't to any fault of our own. It was only recently brought to our attention that there was an issue.
Okay, thanks very much.
Okay, thank you.
Anything else? Thanks.
Oh, actually, I'm sorry. I have pictures.
Oh, you're welcome to show them if you need to.
Okay.
You're also welcome to just submit them in the record. It's up to you.
Well, I did want to show you a couple things.
Uh-huh.
One is another property that has a similar carport. It's even closer to the road. I'm sorry.
I believe there's 2 of them on your street that I saw. 2?
Yes, and actually two of them, it's the same property. It's that one and then this one. Yes, you can see them both there.
What
You
is
can
that,
see-
one on either end of the property? Is that what it is? Okay.
Yes, and you can see how they're very close to the road. And then I just wanted to show you mine. And how it's a bit back from the road, a little more than the others. Just wanted you to see what we were dealing with.
Got it.
And that's all, thank you.
All right, thank you, ma'am. Thanks for the testimony. Okay, is there anybody here today in support of this request? Okay. Seeing nobody in support, virtually or otherwise? Is there any opposition to the request? Any opposition? Okay. With that, I'm going to close variance 20.
Sir?
Yes?
Yeah, if I could add some clarification comments?
Say again, Tom, couldn't hear you.
Hello?
Yes.
Yeah, hi. With regards to the sliver of the lot.
Yeah.
Yes, that sliver had been obtained by lot 15, and it starts off at virtually 0 in the front and then angles slightly back. That sliver had been obtained by lot 15 prior to the purchase by the applicant. However, that sliver, moving it from lot 14 to lot 15, had never gone through subdivision review or approval by Hillsborough County. And so this is actually the revision in the deed to restore that sliver back to 14 was a corrective action taken by the applicant as part of this review for this variance. So again, that sliver had been moved over, but without actual subdivision review. And so it's a corrective action to restore the lots back to their platted state.
Okay, so the eastern boundary of the survey, the 106.98 foot line.
Right.
Do you believe that that is the line with the sliver added back in?
Yeah, well, what you can do is go into the file, right? They've filed a corrected deed that removes the lot 14.
I saw that.
And this had been an ongoing process. They attempted to get a revised survey that took out lot 14, but couldn't do so in time for this. So the heavy black line is identifying the lot line of lot 15 as platted. If you go into the optics file, you'll see a version of, you'll see the original survey was submitted without the black line, and there you'll see it clearly distinguishes the boundary of lot 15, and then it shows the little sliver.
Got it. Thank you, Tom. Anything else before I close it?
No, sir.
All right, with that, we'll close variance 2590. Ma'am, come back up for a minute. I don't know that you need to say anything, but since Mr. Hisney spoke, is there anything else you need to add before I close it?
No, thank you.
All right. With that, we'll close variance 2593.
Okay, our next variance is item G5, application 20-0597. The applicant is Garrett Walker. The request is a variance to lot development standards. Staff findings to be presented by Tanya Chapella.
Good morning, this is Tanya Chapella. Can you hear me properly?
We can go ahead.
Good morning, this is Tanya Chapella, Hillsborough County Development Services. Can you hear me?
Yes, we can go ahead.
The applicant is requesting a variance to the required side yard setbacks to accommodate a proposed single-family home on property zone ASC1. The required minimum side setback for a property zone ASC1 is 15 feet. The applicant requests a 5-foot reduction to the required north and south side yard setback to allow a setback of 10 feet along the north and 10 feet along the south. In a previous notice of request statement, it was included a variance request to encroach the wetland conservation area. However, the applicant revised the survey and it was received on March 10, 2020, and no such encroachment is proposed. Therefore, this variance is not necessary. I'm glad to answer your question.
Okay. And the applicant, please. Yes, sir. Good morning.
Good morning, David Jordan. I'm the attorney for Garrett Walker. My address is 4208 Marchmont Boulevard, Land O'Lakes, Florida. I'd like Mr. Walker to.
I'm Garrett Walker. My current address is 6063 Lakeside Drive, Lutz, Florida 33558.
Thank you, sir.
So just as Ms. Chapella mentioned, we're seeking 5 feet in from the side yards. The parcel is located on Gerasi Road. It's in north central area of unincorporated Hillsborough County. It's a few miles south of Pasco County line, about 1.5 miles or so east of Northdale Mabry. The portion of Gerasi Road that we're discussing runs in a north-south direction. The lots on the east side of Gerasi Road, and I can put a map that I got from Hillsborough County.
Okay.
Let's turn it this way, yeah. Right, so this is Gerasi Road right here, and this is our parcel right here. So the lots on the east side, they're zoned ASC1 for lots that are over 43,500 square feet. But if looking at this map, you'll notice that most of those lots are submerged. So they're actually more closely linked or most closely sized with what's across the street, the RSC4 and the RSC2 down here.
So they're fee simple owned bottoms.
Yes, sir.
Okay.
Yes, sir. So that leaves those lots, and we'll just talk about our lot. That leaves our lot with 50% or less of upland. For example, I have the numbers here. Our lot is 46,609 square feet, about 17,710 square feet of upland. So that's what our buildable area is. The minimum width of those lots is supposed to be 150 feet. I think that this was all a farm maybe back in the 70s. And so it was just zoned ASC1. They should probably go through and maybe change them all. But nevertheless, so the RSC2 minimum width is 100 feet. RSC4 minimum width is 75 feet. And with those widths are the side backs, the side yard setbacks for 100 feet is 10 feet for an RSC2. The side yard setback for RSC4 is 7.5 feet. So it seems to be concurrent with how wide your lot is. So since these lots are supposed to be 150 feet, that's why you're supposed to have 15 on each side. However, these lots are 90. So, assuming that we followed logic, it would be maybe 9 feet on either side. We did submit an application that this property be legally non-conforming, so we do have a certificate of non-conformity. And a couple last things. There are other lots on the east side of Gerasi Road that have less than 15 feet. I don't know if they've been grandfathered in or they didn't request it. We're not trying to rat anybody out, but for instance, and this particular parcel that I'm going to talk about, he actually in 2004, he requested very similar side yard setbacks. He requested 11 feet. So we're asking for 1 foot more, and that was granted. If the chair wants to look at it, it's variance 04-570. This here. Our lot is the one with the X on it. I feel like a weatherman. Our lot's this one right here.
Gotcha.
And so about 6 or 7 houses up, this gentleman built a house, obviously back in 04, and he received actually a front and the side yard setback. So we're asking a very similar thing. So it's going to be pretty compatible with other homes in that neighborhood. One last thing that I will show, 2 last things that I will show, 3 last things that I will show. Lawyers never know when to shut up. This is the house that I just spoke about where he received the side yard setbacks and the front yard setback. Here are, just to show other similar homes. So these are nice big homes, but you can see that that's not 15 feet. And I'm assuming that the fence is the dividing line. I don't have a survey of this home. These are a bit to the north of my client's lot. And one last picture I'll show is a few houses to the south, very similar. I didn't get out there with a tape measure, but that doesn't look like 30 feet to me. But nevertheless, the house that my client proposes is this. I mean, of course, this is not, this is a zoomed in picture of what it's going to be, but I put this in here just to show that it's in conformity, in harmony with what the neighborhood has. So I believe we've hit all 6 of the requirements, first being the hardship. Practical difficulty is unique and singular as regards to the property because the lot does not meet the required lot size, legally non-conforming. Literal interpretation of the provisions of the LDC would deprive my client of the rights commonly enjoyed by others, considering other homes in the vicinities have very similar side yard setbacks. As I've said before, the request is in harmony, serves the general intent of the LDC. The situation is not the result of any actions of the applicant. He hasn't even built the house, hasn't even broke ground yet. And the public benefits intended to be secured by the LDC are not jeopardized when weighed against the hardship to the applicant. So with that, I'll go ahead and close. And if you'd like to ask questions,
Brief question for you. Did you actually apply for the zoning legal nonconformity application?
We did, yes, around the same time that we put in the variance.
Okay, and when was it determined that the lot was created?
It was created in 1970.
Okay, that's good. That's almost enough for me. In the 1970s?
In the 70s, correct.
Okay, so it later was put through zoning conformance in the early 1990s. Did you remember reading that on your zoning legal nonconformity letter?
No, sir, I did not.
Okay, Tom, does that make some sense to you?
Well, yeah, but the review for a legal non-conforming lot is simply that there was a recorded deed for that lot prior to July 26, 1989. There's no other review criteria, and that the lot hasn't changed since that time.
Okay. All right. Anything else, sir?
No, sir. I'll just go ahead and submit these into the record.
All right.
And we have a larger. When we were submitting this, the whole coronavirus matter came about, and so what we did was we submitted the survey that we have in parts. So we have a larger survey that we can submit. Do you need this? Yeah, and we actually had this prepared as an exhibit, so we can submit this into the record along with our pictures.
Okay, thank you for your testimony.
Thank you, sir.
All right, is there anybody here today that needs to speak in support of this request? Anybody in support? Okay, I see none. Is there any opposition to this request? Any opposition? All right, sir, if there's nothing else from you, if you just let me know. Otherwise, we're going to close it.
Thanks, sir.
All right, thanks. And with that, we'll close variance 2597.
Okay, we have no special uses. That should take us to section I, the appeals. There is one appeal. Mr. Hearmaster, I noticed that during the course of this last hearing, the appellant, Mr. Davis, left the lobby.
Okay.
So if we might obviously need to take a break.
Yeah, let's, why don't we do that? We're going to take a very short break, but we'll take, let's say 5 minutes. We'll give the appellant a chance to get back into the room. And then I'll go through quickly with you why this hearing is a little different from what those who are listening have already experienced. So 5 minutes from now, we'll be back.
We are live in 3, 2, 1.
Okay, ladies and gentlemen, we're calling our hearing back to order. Now we're going to move into the last agenda item, which Mr. Hisney will introduce in a second. But suffice for the moment for me to say, since I mentioned it's a little bit of a different process, this is the appeal to an administrative decision. The cases of appeal from the administrator to the land use hearing officer are governed by section 100500 of the Land Development Code with its own specific provisions. A couple of notes for you about that is that basically what you have here is the case of a appellant challenging the decision of the administrator. So it's basically limited to the evidence that was utilized by the administrator to make his decision. Okay. There's some other nuances in that within the Land Development Code, which I hope the appellant has read, but that's the basic point. And in so much, it's not appropriate to bring in other forms of evidence that haven't followed the procedures within the Land Development Code. Secondly, since it is between the appellant and the administrator, but there's a property owner who is affected, the property owner will also get to participate. There are no other parties. There is something that could be another party called an intervener. I didn't see any in the file. Mr. Hisney, can you tell me if anybody filed as an intervener in this appeal?
No, sir.
Okay. So there are no interveners. So basically, I'm going to take testimony from the appellant first, from the administrator, and then from the property owner. And that will be the extent of this, all limited to the evidence that's on the record. And then we're going to get to, at the end of this, because I want to hear the testimony, but we're going to get to the decision time frame based on what I received that we'll talk about following that testimony. So with that, I'd like Mr. Hisney to introduce the request.
This is appeal number 20-1035. The applicant is appealing the administrator's decision in zoning verification ZV 20-0771 amended, dated June 10th, 2020, concerning property located at 618 Marfil Loop in Brandon.
Okay, thank you. Now we have the appellant. Is the appellant available? The name is Sumter Davis.
Good morning, gentlemen.
Good morning.
My name is Sumter Davis. I reside at 619 Marfil Loop, Brandon, Florida. I'm here today with a lot of my neighbors.
Mr. Davis, one second. Okay, so you heard a little bit of what I laid out here and the position that you're in at the moment as the appellant. So your interest here is demonstrating error. That's specified in the code. So you would have to demonstrate to me that there was an error in the administrator's decision in order to prevail. Having said that, go ahead.
Well, actually, I was under the, I'm not very well today, sir. The paperwork was done by Kathy Weber, and she was supposedly scheduled to appear, even though this was in my name, to represent me today.
Sir, there's nothing I can do but your representation. This is your opportunity, and it's here
Well,
for
can
you.
I let her, since she was listed on the paperwork?
Oh, she was listed on the paperwork?
Yes, on your paperwork here today, it says Kathy Weber.
Okay.
Mr. Scrolla this is Cameron. Can you hear me?
She's listed on the application as. Yeah.
One moment. Go ahead, Mr. Clark.
Yes. Is Ms. Weber his attorney? He's entitled to legal counsel. If he has an attorney, she can represent him.
Is she counsel or no?
Yes.
She's legal counsel? She a lawyer in Florida?
No, she's
Okay,
not.
thank you. Hold on,
Mr. Clark, she is not a lawyer.
Okay. Yeah. So legal counsel means any party may have an attorney represent them, but simply having, I'm not sure if, having another neighbor represent would not be the same thing. I mean, the difficulty with these cases is that under the code, certain parties have standing to appeal, and obviously people within the affected radius or people who are parties that are described in the code as having standing can also intervene in an appeal. In this instance, only Mr. Davis appealed the case, and no one else filed to intervene. The code describes that any party, whether they're an appellant or intervener or even staff, can have an attorney represent them. But it can't just be someone else coming up who's not the attorney retained by the appellant.
Bear with me 1 second, Cameron. Carmen, can I see the application itself? Do you have it available?
Don't have any paper.
I'll look at it on there as long as I can access it. You have it, Tom? Cameron, you still, ma'am, just hold on for a second. I'll let you know when you can speak. Cameron, you still with me?
I'm here.
The application has the applicant as Sumter Davis, and then it has a blank for applicant's representative, and it lists Kathleen Weber. And the application is an appeal of administrative decisions. I just want to check with you and make sure that there's no change in your perspective on it.
No, I guess my concern is just that I know from looking and I think discussing with the staff beforehand that Mr. Davis meets the standing criteria based on, I believe, and Mr. Hisney can confirm, but I believe based on his ownership of property within the proximity, I believe it's the 500-foot proximity of the property that was the subject of the administrative decision. I don't know that, I mean, I think the issue is we don't know anything about Ms. Weber's standing. I would be reluctant to just state, yes, she can just go ahead and speak on her own behalf because we don't know her standing to have appealed the case or intervened in the appeal. And also, since she's not his legal counsel, she couldn't speak on his behalf. I suppose since her name is on the form as well, I don't know if we want to look to see what standing, does she meet any of the standing criteria for the application, which is described in 100501.
Thank you, Cameron. Give us a chance. Mr. Davis, just bear with me for a moment here. All right. The representative put her address on there. Tom, have you already checked to see if that address is within 500 feet of the subject property?
By measurement on our GIS, it appears to be more than 500 feet.
More than 500
Yes, sir.
It doesn't meet that criteria.
So Mr. Scarola, the only other criteria for standing, so if you'll look at, I don't know if you have in front of you, but 100501B2 sets the standing for an appeal. The first one is just the applicant for the admin decision, which in this sense would be the property owner. The second one is also the property owner that's subject to the decision, so that's not applicable here. The third one, I believe, is the one that Mr. Davis falls under because he's an owner of real property on the current year's tax roll that lies within 500 feet of the subject property. I think Mr. Hisney is stating that Ms. Weber's property is outside that radius. The final criteria is any resident landowner or any person having a contractual interest in land in unincorporated Hillsborough or a duly registered neighborhood organization as described in the code who demonstrates an adverse impact as a result of the decision.
Well, I'm actually,
One second, Mr. Clark.
I'm with them, but the word is not or, Cameron, it's and. So it was unincorporated Hillsborough County and any duly registered neighborhood organization. I just wanted to make sure because you threw in the word. Yeah. So go on, Cameron.
But the important part that follows is who demonstrates a direct adverse impact as a result of the administrative decision that exceeds in degree the general interest in community goods shared by all persons. And then it says that the LUHO shall make a determination if there has been a demonstration of adverse impact sufficient to grant appellant or intervener status. It says, however, any information considered in making such a determination shall not be considered a part of the record. So essentially, it would appear that Ms. Weber does not meet any of the first three criteria, because she's not the applicant, she's not the property owner that's the subject of the decision, and she doesn't live within the 500 feet. Therefore, the only one I would think that she could fall under would be the final one, which is to show an adverse impact sort of that's greater than just the general interest in the community good. And that is a decision for the hearing officer.
And Mr. Hisney, as far as you know, that any information in support of that position, I didn't see it in the record. Have you seen any information submitted so far that would demonstrate that?
I have difficulty hearing the virtual speakers, very echoey here. What was?
Okay, so assuming that the person does not meet several of the other criteria, the very last criteria is they would have to demonstrate a direct adverse impact as a result of the administrative decision that exceeds in degree the general interest in community good shared by everybody. So in this case, her direct adverse impact would have to be greater than the rest of the people who are involved, and she's outside the 500-foot radius. All I'm asking you is, has anybody submitted information to that extent so far?
No. Well, other than the letters that were submitted into the file.
Right.
But yeah.
Because we submitted signed petitions the first time around, and then we submitted 35 letters the second time around.
Yeah.
All the neighborhood residents.
Yeah. Okay, so far you haven't talked on the microphone, and you said that information is not on the record yet. I'm going to step over to the microphone. State your name and address, please.
Give me the papers.
Kathleen Weber, 630 Marfield Loop, Brandon, Florida.
Okay, Ms. Weber.
Yes, sir.
Your house lies outside the 500-foot zone.
Yes, sir.
It's my decision that you don't meet the first of the criteria through criteria C. The first three criteria you don't meet. Criteria D says to the extent that you demonstrate direct adverse impact as a result of the decision that exceeds in degree the general interest in the community, which means your direct impact would have to be greater than everybody else who is part of the community.
I'm the only one in the neighborhood that has a spouse that has Alzheimer's. If she gets out and those people are there, they don't know her, they could do something to her. And also the gentlemen that live in the group home where we are now are ages 20 to 25, but their mentality is ages 10 to 12. They could be abused, or, anything could happen to them because of these girls there. We don't know anything about these people that are coming in this house. We have no background checks. We know nothing.
So you believe you have a special medical concern?
Yes, with my wife having Alzheimer's really bad. She's had it for 7 years. And I'm concerned because she doesn't do well meeting new people. And if those people were, to say something to her or whatever, she may freak out and run off, and then I'd never be able to find her because she gets lost very easily.
Okay. So here's what I'm going to do. I'm going to let you speak, okay? And I'm going to make a finding that you are supported under criteria D, okay?
Thank you.
But this is going to be limited to a total of 15 minutes. Okay?
Yes, sir. Won't
And
take that long.
you only have one goal here if it's to overturned the administrator's decision, and that's to demonstrate error. E-R-R-O-R, error.
Gotcha.
Okay, so with that, the floor is you. I guess I want to make sure that Mr. Davis doesn't have anything else to add. If he's going to relinquish.
Yeah, I just
come on over to the microphone.
I could not hear the opinion or the advice over the virtual.
Yeah.
So I'm very confused at this point.
You're what?
I'm very confused.
You're confused.
Yes, by what my rights are here.
Okay, well, I can't help you.
I couldn't hear them.
If you haven't read the Land Development Code, I'm certainly not here to counsel you, but this is the opportunity that you have to demonstrate error by the administrator, and you appear to hand this over to the other person on the application. So do you need to speak or no?
No, I'll let her speak.
Okay, well, that's all I need to know. Floor's all yours, ma'am. Let's put
Okay.
15 minutes on.
Mrs. Walker, representing Miracles Outreach, requested back in 2019.
Ma'am, I apologize. Mr. Davis, could you sign in, please?
Sorry.
I'm sorry.
That's
Go
okay.
ahead.
Mrs. Walker, representing Miracles Outreach, requested back in 2019 a variance in the zoning verification of the single-family residence located at 618 Marfield Loop. She wanted to install a group home, and her request was denied due to the fact Marfield Loop already had a group home less than 800 feet from her property. I already said the part about the guys would be at risk if all these ladies are there because we really don't know anything about them. Her request was denied in a hearing December 16th, 2019 because of the close proximity. In April 2020, Mr. Hisney notified via email several residents of Marfield Loop of Ms. Walker's request for zoning verification, ZV 20-0711, changing her request from a group home to a host home / shared housing program that will provide a supervised living setting for young women ages 18 above leaving the foster care. Mr. Hisney, in his letter dated April 29th, went on to write a very detailed and eloquent letter on behalf of Mrs. Walker concerning the host home she was proposing. In his letter, it was 2 pages, 5 paragraphs, very detailed, elaborate, and even advocational in his writing about her proposal, elaborating with verbiage even Mrs. Walker did not use. At the end of this letter, he also denied Mrs. Walker's request due to the restrictions of the Land Development Code, stating, requirement of the front, rear, and side building setbacks of 50 feet, which this home on the property does not meet. Once again, her request was denied. Finally, on May 11th, she completely abandoned her request for any host home and changed her request to be that of a shared housing program for young adults, eliminating supervision, eliminating only women, and apparently including men to share this housing. This most recent request is for a rooming house. That new request can be verified in her permit submitted on July 21st. The request for permits was totally changed and reads 1 to 2 family dwelling undergoing a change of occupancy into a lodging rooming house. The new initiative is to have young adults, not children, to learn life skills and better their lives. They are over 18, therefore this will not be construed as a group home. Once again, she's contradicting herself, saying this will be a rooming house, which is a house with rooms to rent, and saying they will be learning life skills to better their lives. Mr. Hisney again replied to her letter dated June 10th. Mrs. Walker's request was a 1-paragraph letter. Mr. Hisney was once again 2 pages and 4 paragraphs later, a detailed letter of her intentions. Our only conclusion is he has assisted her in her pursuit to turn this home into a group home, shared housing transitional living home, thereby eliminating the need for any hearings for a variance that may have been required. It is obvious that she is manipulating the system by insincerely conforming all her requests to avoid any variances or neighborhood interventions. This home is only 1,700 square feet with a converted garage. It states on the taxation website it is a 3-bedroom, 2-bath home. However, she is representing it as a 5-bedroom home. The parking available in the driveway is only for 2 cars. That will mean that her tenants paying boarders will have to park in the street, which is not allowable because Marfield Loop has no curbs or sidewalk. It's only a 2-lane street. Therefore, there's no legal parking available. We have experienced many disturbances with the group home for their unlawful parking. The cars that park in front of 618 could be up to at least 5 plus any visitors. These cars could be on the street, causing all the residents of Marfield Loop to maneuver around the cars and children to ride their bikes or jog around all these parked cars, which would be unsafe. This home is located 6 houses from the entrance, which means 90% of the residents will be forced to pass in front of this rooming house. Marfield Loop is considerably very quiet and consists of families with small children and older adults. The amount of people in this house that will attract is a grave concern to all of our residents. That can be determined by the letters from Marfield Loop residents who were submitted in support of this appeal. If Ms. Walker is truly going to turn this into a rooming house, that is even more concern to the residents. The clients that will be in and out of this home will be troubled young people, which are individuals that Miracles Outreach deals with, disrupting our neighborhood. I don't believe Ms. Walker has any other rooming houses. Ms. Walker will be collecting rent and should be legally responsible for verifying the status of her boarders, meaning there will be no pedophiles, substance abusers, drug addicts, or drug sellers. Since she is exempt from paying taxes, how and whom is responsible for issues such as trash pickup, school taxes, etc.? We pay taxes on our home, and they include various things such as waste management, school taxes, street lighting. Who's going to pay for all this at that house? We have a report about rooming houses stating if rooming houses are permitted to spread to the city's 1 and 2 family neighborhoods, there's not much use in talking brave words about fighting the blight. Rooming houses are not compatible with 1 and 2 family districts. When rooming houses come in, the families move out and the whole area goes downhill. Rooming houses have become notorious as both symptoms and causes of neighborhood decay in many big cities. This rooming house shared housing group home will also cause property values to plummet in our neighborhood. As one last item of concern, Mr. Hisney has been the main contact and corresponding with the residents of Marfil Loop on the behalf of Ms. Walker. He was given the approval by the committee of Miracles Outreach for this rooming house, clearing the path for Ms. Walker to basically do what she had originally requested against us. Thank you.
Okay, appreciate you putting that on the record. Now tell me.
Yes, sir.
Succinctly where the error is in the administrator's letter.
It seems like every time, sorry, I know I forget, not used to being on the microphone, sorry. Every time she went to submit a new thing, he would tell her and write a letter for her and tell her what words and what verbiage to use. He is a city employee. He's supposed to be working for everybody, but he's not supposed to be usurping the system and helping people to get variances when they aren't supposed to be getting them.
Okay, so listen to me carefully now. These are things, these are peripheral items that suggest that you don't like the way it occurred, which I can understand, but it doesn't point to the definitions that were used in the letter and where the administrator went wrong.
Because the letters that she submitted had nothing to do with what he submitted. He wrote basically the letters for her and told her what to say to get the approval.
So where is the technical error in the letter?
Because why is he allowed to do that?
Well, that's process. It's not the error in the letter.
Well, if an employee that works for the county, that's our county and supposed to be looking out for the welfare of the people in the neighborhood, how is that good?
Okay. Anything else, ma'am?
No, sir.
All right. Thank you for your testimony. Mr. Hisney, for the administrator.
Yes, sir. I'm going to provide a timeline that's actually going to, part of it is going to precede the zoning verification. Some of the things he referenced in her statement are actually preceding the zoning verification, just for clarification purpose, and then we'll get into the zoning verification. So back in November of 2018, Miracles Outreach, the property owner, had applied for a zoning verification, sign off on a community residential home type A on the subject property. These are very standard sign off. The requirement under our code is just one, that there's no other such home within 1,000 feet. Well, there is one within 1,000 feet. Miracles then was advised that they needed to apply for a variance to that separation requirement. They waited approximately a year to apply for the variance. That variance number was 20-0143. And it was heard by the LUHO in December of 2019. That variance was denied. Miracles then filed an appeal of that denial. That appeal number was 20-0498. And then in April, and she filed that in January of
2020?
2020, yes, sir, because the variance was denied in December of 2019. January 22nd, 2020, Miracles applied, again, appealed the denial of their variance for the community residential home. In April 7th, 2020, Miracles then withdrew the appeal. Then contacted our staff saying that they wish to use the property not for a community residential home, but for a different type of home. And then this is where we enter the zoning verification. They were advised that they needed to submit the details on the type of home they were proposing, because the details are important. So they submitted a zoning verification request, and this now is zoning verification 20-0771, which is what the subject of this appeal. However, when you go into the optics record, you're going to see there's 3 different letters issued by our department in connection with this zoning verification. So I want to take you through that, so when you go into the record, you'll understand what you're seeing. So the first verification they submitted, even though Miracles had been advised to provide details about the home, it was just simple zoning verification. We have a form online. All it asks is, what's the zoning of the property? No other detail. We provided our standard response letter, which you'll see in the record, dated April 23rd, 2020. Simply advises what the zoning of the property is, and you can go into the code and you see what's allowed, right? So Miracles then asked, well, gee, you didn't address the home. We said, well, you needed to provide details about the home you want to put there. So they then provided a number of details, which led to the issuance of a second zoning verification. This one is dated April 29th, 2020. In that zoning verification, and if you go into the record, you'll see what was submitted by them. There's a description of the use that was as described by Miracles, right, as what they were proposing. Our verification determined that what they were proposing was a life care treatment facility as defined by the code. And a life care treatment facility is a special use of the subject property, which then would have required a public hearing, approval of a special use permit for a life care treatment facility. We also noted that the review standards for a life care treatment facility found in the code, that it was obvious they didn't meet one of them, which is a 50-foot setback on all sides for the structure being utilized by that, and advised them as part of their special use, they would have to incorporate a variance request to that setback. Advising them of the process, not approving or denying anything, just saying, here's the process, you must apply for a special use. That was issued on April 29th, 2020. So sometime later then, Miracles comes to us again saying, okay, we want to revise what we're doing. We understand this is a special use. Then we're gonna change what we're doing on this property. They submitted a letter for that revision.
What's the date of that, Tom? If you have it.
Yeah, the date of their letter it's dated May 11, 2020. We received it June 2nd. If you go into the file for this zoning verification, this is the one that's being amended. It was issued on June 10th, 2020. This decision is zoning verification 2771 amended. And this is what's being appealed.
Gotcha.
Right. So based on their description and the letter that we sent out, the zoning verification included the letter they submitted with the description of their use and some relevant definition. We found that what they are proposing for the property as described in their revised amended application is that we found that it is so the property is zoned RSC6. A single family dwelling is a permitted use of the property.
I'm sorry, RC6?
The RSC6, yes, sir. A single family dwelling is a permitted use of the property. The shared housing program as described in your amended request appears consistent with the allowable use of a single family dwelling as regulated by the Land Development Code.
Tom, I apologize for doing this, but so the words share housing that you propose, is shared housing a defined word, or was that a generic?
No, that's her wording.
That's
She
her
called
wording.
it a shared housing program. But we stated that, and again, you'll see their letter, our letter that we sent out on June 10th includes their statement of proposed use. And it says that we find that appears consistent with the allowable use of a single family dwelling, provided the home is occupied by no more than 5 unrelated persons at any time. Each room is rented on a weekly or longer basis, and no personal care services as defined by the LDC are provided to the residents. Additionally, the program cannot be licensed as a community residential home or professional residential treatment facility. So our review here is based on the information that's submitted by the applicant. Yes, the applicant has revised their proposed use, the description of their proposed use. Going way back, it was going to be a community residential home. Then it was changed to a use that we found to be a life care treatment facility. They amended it again. So we need to base our verification letters or any decision we make on the evidence that's submitted by the applicant, and it's based on the described use. We feel that this verification is correct. I will take, and as referenced in this, you'll see that we have the definition of a single-family dwelling, a dwelling unit, and a family. And when you read those, a dwelling unit is a room or groups of rooms forming a single independent habitable unit that is used for, intended to be used for, or may be used for living, sleeping, sanitation, cooking, and eating purposes by one family only. And for owner occupancy or for rental lease or other occupancy on a weekly or longer basis. Now, you go to the definition of family. A family is any number of people related by blood, marriage, or adoption, or not more than 5 unrelated persons living together as a single housekeeping unit.
Says that.
Yes, sir. That's in the definition of family. And again, that's attachment 2 of the zoning verification letter issued on June 10th, 2020.
So I want to make sure I repeat. 5 unrelated.
Yeah, no more than 5. You can have any number of people that are related by blood, marriage, as described, or no more than 5 unrelated persons. So as described by the applicant, this is a single housekeeping unit. Everyone, is living there together, sharing the facilities. Yes, they're independently paying rent, but that's not inconsistent with the definitions I just told you. They are the verification we provided says you're not going to provide, they can't provide personal care services, cannot be a community residential home or professional residential treatment facility. Those uses are also defined in the code. So it says what is allowed, says what's not allowed. And we found this to be consistent with the permissible use of a single family home in RSC 6 district.
Tom, were there any other definitions that came into play? Because I know you're thorough when you go through your code. As an example, is there anything out there like rooming house? Yeah. Or tell me what you can.
Sure. During our review on that, we did took into account other definitions. Definition of boarding house, right? Is a building or group of buildings containing in combination 3 or more lodging units intended primarily for rental or lease for periods of longer than 1 week with or without board. And then lodging unit is in turn defined a room or group of rooms forming a separate habitable unit used or intended to be used for living and sleeping purposes by one family only without independent kitchen facility, or a separate habitable unit with or without independent kitchen facilities occupied or intended to be occupied by transients on a rental or lease basis. A dwelling unit, on the other hand, is a room or group of rooms forming a single habitable unit and shall contain an individual kitchen, which of course the house does. So we found that.
I don't want you to go ahead.
Yeah, so looking at these definitions in our review, we found that boarding house we felt was not applicable to this use, and that it fell under the definitions of a dwelling unit.
This structure didn't have lodging units, which kind of kicked it out of boarding house.
In our view, yes, sir. But yeah, we did look at those definitions and felt they did not fit what was described by the applicant.
The dwelling unit did.
Right. Yeah, in our view, yes, sir.
Okay. Are there any other definitions?
Well, there's other definitions in the code, like community residential home. Well, the verification says you can't be one of those. Also, professional residential facility definition says, the verification says you can't be that. Both of those which would require other approvals anyway. And then we also made it clear that you cannot provide personal care services, which are defined in the code, and that they cannot provide those on the property either.
I'm just going from memory here, but in your letter, did it say something to the effect of only 1 person per room, or did it not say that?
Fine. So the letter we issued, first of all, our letter we issue, and what we do in these verifications, particularly when, somebody sends us a verification request and says, can I have a gas station on this property? Okay, well, we all know what a gas station is. We don't really need to define it, right? Well, our code doesn't have a definition of a shared housing program. So we incorporate into the letter and attach in this case, their description of the use. So there's no misunderstanding as to what they proposed and what we evaluated, okay? So in there, they state each residence will have their own room and share the common areas. So that's the answer to that, but that's from their statement is that each resident will have one room and share the common areas and facilities.
Well, so what are you thinking if you hear evidence that says that it's a 3-bedroom, 2-bath, but we're going to put 5 people in it?
Well, they didn't state the number of.
No, but does that concern you if you hear it today?
No, because the code says 5 unrelated persons.
It doesn't matter how many bedrooms.
Right. Doesn't matter how many bedrooms. If we'd have been aware of that, there was a 3-bedroom house, it wouldn't have affected our review because the code says 5 unrelated persons in a single family dwelling. It doesn't matter how many bedrooms are.
What do you see the difference between what is being proposed here and community residential home?
Well, first and foremost, community residential home has to be licensed. And then when you go into the code, there's also different services. Let's see without looking at, well, the key difference is it has to be licensed. And this is not going to be licensed and it can't be licensed. If they seek a license for a community residential home, they're back to where they started, which is they need a variance to the separation requirement. Let me flip into the definition of community residential home. Okay, so, but the fact that the licensing, that alone makes them not a community residential home. Let me go to the definition, please. Yeah, so also in a community residential home, you have to provide housing, food services, and one or more personal care services. So in this case, they're not providing food as described, and they're not providing personal care services. And in fact, our verification states they cannot provide personal care services.
Anything else, Tom?
No, sir, not unless you have questions.
No, I think I'm good there. Now, as I mentioned in the beginning, the property owner will also have an opportunity to speak. So is the property owner here, and does the property owner need to speak? Yes, ma'am.
Mr. Scroll, this is Cameron Clark. May I speak real quick? Can you hear me, sir?
Go ahead, Mr. Clark.
Mr. Scrolla, I want to clarify this with Mr. Hisnay. I think I honestly, this slipped my mind until just now. I believe, and Mr. Hisnay should be able to confirm, was there an additional evidence submittal by the property owner? Tom, is that correct?
I believe there was, and it should have been submitted into the optics record.
Okay, well, where I was remiss, Mr. Hearing Officer, there needs to be, and honestly, this should have been at the start of the hearing, but at a bare minimum, it should be before the property owner speaks. If you look at section 100501 D4, so part D talks about the conduct of the hearing, and D2 and D3 talk about the types of evidence that can come into the hearing. However, any party is able to, it says, evidence other than that listed above must be presented. If they believe that in order to fully present their case, evidence other than that listed in subsections 2 or 3 above must be presented to the hearing officer. The nature of the additional evidence must be disclosed to the other parties and the hearing officer not less than 5 days before the hearing. It says at the beginning of the hearing officer shall rule on whether such additional evidence may be presented, and the hearing officer shall freely allow the presentation of additional evidence pursuant to this subsection where such is relevant to the issue on appeal. I know that this additional evidence did come in ahead of the 5-day requirement, so there's nothing, if it came in after that, it would be precluded. It did come into administration in time for the 5-day, the 5-day requirement, and it was immediately transmitted to the appellant, Mr. Sumter. generally the owner who had received a favorable ruling from the administrator wouldn't be presenting additional evidence because they already received the ruling. But I mean, because it's additional evidence and it meets the requirements in order to be able to come in, if the hearing officer finds it relevant, I think prior to that, you would want to make a determination as to whether that evidence can be considered at the hearing or not.
Thank you, Mr. Clark. So,
I did not understand everything. So
ma'am,
did you
I
need
can't.
me to
you
speak or
can-
not
hold,
speak?
hold on. Go to the microphone. Name and
Okay.
address first.
Okay.
Yeah.
Michelle Walker, representative for 618 Marfield Loop Miracles Outreach.
Okay, now give me 1 second. This. Okay, bear with us just a minute. I want to see this additional evidence. By the way, while they look, is it still your inclination to utilize this additional evidence, or did you want to withdraw it? It's up to you.
I didn't really submit additional evidence. I was responding to the information. It was just the clarification of the, we did change 3 times, but each time was based on us meeting, well, our team meeting and trying to be able to still accomplish the goal, but still at the same time comply with the zoning and meet the request of the neighbors. That was pretty much it.
Okay, so the word additional evidence simply means that the appellant appealed, right? And the administrator has his package making the decision. So anything else that comes into it after that point is additional evidence.
Oh, okay.
So that's what you did. And
Okay.
depending on whether, remember, the issue here is whether the administrator made an error. And so if you now are listening to this and saying, I don't really need that evidence, you're welcome to say, because at some point you're welcome to say, I don't need it and I don't want it in the record.
I don't need it for that. It was just in response to what they were saying. It was nothing that was additional. It wasn't considered additional evidence. I didn't think it was additional evidence. I was responding.
So there's no grayness here. You either say it's in or it's out. It's up to you. You want it in, I'll consider.
It's in. I'll say it's in.
Okay, that's fine. Maybe give us a minute.
Okay.
$5 minutes do it, you think, or a little longer? Sorry. No, I'm asking you 5 minutes or longer? All right, we're going to take a 5-minute recess and we'll go right back to it. take their seats, please, and we'll wait for staff to get the hearing back up and running again. Kindly take your seats.
We are live in 3, 2, 1.
Okay, thank you. We'll bring our hearing back to order on Appeal 20-1035. And the property owner again, please. Yes, ma'am. Thank you. Your name for the record?
Oh, Michelle Walker.
Ms. Walker, could you describe very briefly what the additional evidence was?
It wasn't really evidence. I didn't understand what was saying. That's what I was asking. I couldn't understand. It really wasn't additional evidence. It was just a response and pictures. It was letters of support. It wasn't evidence. It wasn't evidence,
Letters of support and pictures.
Mm-hmm.
Okay, kindly have a seat for just a moment.
Yeah.
Okay. And the appellant, can I have the appellant, please? It'd be Mr. Davis in this case. Mr. Davis.
Mr. Davis, 619 Marshall Loop.
Thank you. Mr. Davis, did you receive last week anything from the county indicating there was some additional evidence filed in the form of a letter or pictures? Did you receive?
Yeah, it was a very, very hard to open, very large file.
You did receive it though?
Yes, I did.
Okay, thank you for that. Okay, and then the property owner again. Yes, ma'am. Okay, ma'am, the best I can make of it is this additional evidence, which I have not seen, was sent in timely, and it was received by the appellant, okay? So did you want, I still have to opine, make a decision on whether it's admissible or not, or we're going to take it in. Did you want to describe it to me and tell me more about why you submitted that information?
I submitted it based on the letter from the neighbors that was sent in. So I was just responding and provided the pictures and the letters of support.
Okay. All right. So ma'am, I am not going to accept that additional evidence because it doesn't go directly to the question at hand, which is the determination.
Fine.
So we're going to leave that out of the hearing record.
Okay.
And now you do have an opportunity still to respond to anything you heard if you need to add anything else in.
To respond to
you can testify right now as to anything with regard to this decision by the administrator and the appeal that you heard today.
At this point, I really don't have anything else to add. I'll just leave it as is.
Okay.
All right.
That's fair enough.
Thank you.
So thank you. And now, with that being said, we've heard from the appellant, we've heard from the administrator, and we've heard from the property owner. The code prescribes that I have 5 working days to make a decision. So with that, I'm going to close this appeal request, 20-1035, and I'll have a decision in 5 working days. And I believe that will also do it for our hearing today. So thanks for everybody's assistance.